Thank you so much for being here today, everybody. My name is Chanel West, and I'm a part of the 10 Talents team. I'm really excited to be here with you all and learn about this really important topic. Before we dive into our topic stuff, we want to go over a couple of Zoom logistics. The first being that we're going to keep you guys all muted during the presentation. If you're having any technical issues, if you have a question like you can't hear or there's a problem with the audio, go ahead and drop that question in the chat box at the bottom of the screen, and Cheryl's going to be monitoring that. If you have any questions during the presentation today that you want to ask our presenter, then you can go ahead and put that in the Q&A box that is next to the chat at the bottom of the screen. And then at the end of the presentation, we're going to ask the questions that are in the chat, and you'll also have the opportunity to unmute at that time and verbally ask a question if there's questions that still haven't been answered. And we also want to let you guys know that we are recording this webinar. So if there's something that you miss or you didn't get your notes exactly right, no worries, because we will be posting this so that you can view it after the webinar is completed. For all of you who registered ahead of time, we do have your email too, so I will send out an email version of this to you after the webinar, and you'll have that. I want to give a quick introduction about the 10 Talents Foundation for those who might not be familiar. 10 Talents is a regional Christian community foundation in Fresno. Our mission is to provide Christian families, individuals, and nonprofits with a charitable platform to leverage their resources for greater impact. And our vision is to mobilize a movement of generosity, both regionally in the Central Valley and around the world. And we are super excited to have this opportunity to provide some resources to our community in the area of wills, trusts, and bequests. Hopefully, this webinar is just the start of many. I'm going to give a couple of statistics just to set the stage before we jump into our awesome speaker. The topic today obviously is wills, trusts, and bequests, because that's what we titled the webinar. And what we found is that around 35% of Americans, so about a third, have a will or trust in place, which means that around 2/3 of us do not. 50% of people, unsurprisingly, I would be one of them, who don't have a will or trust in place, report that procrastination is a main reason. 15% who don't have a will or trust in place state that not knowing where to start is another main reason. And being here, if that's you, being here on this webinar today is going to be a really great opportunity just to help you know where to start and how you can take a next step in that direction. In 2022, Americans donated around $45 billion to charity through bequests. Charitable bequests is something that if you're not quite familiar with, we're going to learn more about that today. And around 18% of people who do have a will have a charitable component in their will. Another interesting fact is that over the next 20 to 25 years, around 50 to 70 trillion dollars, this is in the United States alone, will be transferred through wills and trusts. And that really highlights the important stewardship opportunity that this area is, and the opportunity that we have to steward that money really well for upcoming generations. Now, before I introduce our speaker, we're going to give a couple of quick polls just to gauge where our participants are at in relation to this topic. So they're going to pop up on your screen, and we'll give you about 45 seconds to answer. Just choose the option that best fits where you're at. First question here, you should see it popped up on your screen, is do you have a will or trust in place? You can answer yes, no, or no, but I plan on making one soon. So we'll give you about 30, 40 seconds to choose your answer on that. Okay, and then looks like those questions have come in. So we're going to go on to the second poll, which is specific to charitable bequests. Go ahead again and just choose the option that best fits with your situation. If one of the reasons that you're here today is you're not sure what a charitable bequest is, then you can just choose the last option, which is I need more information to make a decision. Okay, awesome. I think we got those results in. Go ahead and finish up that poll if you're still answering. But without further ado, I'm going to move on to introducing our speaker for today. We are really blessed and excited to have Alice Dostálová-Busick with us today. She is volunteering her time and her expertise to talk to all of us. And we're really just honored and blessed to have her. Alice is an of-counsel attorney. She works in the trust and estates practice here in Fresno. Her work focuses on basic and advanced estate planning, wealth management, trust administration, business succession, and probate. She assists clients with creating estate plans that bring them peace of mind by developing, implementing, and funding personalized plans. She has a wealth of experience and knowledge that she's going to bring here today. And I think that this is going to be a really great presentation. So without further ado, I would like to turn it over to Alice for our main presentation today.
Thanks, Chanel. Thanks for the lovely introduction. Good afternoon, everyone. I'm hoping that this little small webinar will give you guys some information if you don't have any estate plans, if you've been thinking about doing one, and if you already have one, hopefully refresh your mind. Remember, any piece of this webinar could go on for hours, and so we're going to be taking a really bird's eye view of what estate planning is, what wills are, what trusts are, and what it means to not have a plan. So you may have some questions after this is over, and I'm happy to answer those and or direct you to where you can get those answers. So we'll go ahead and get started. What is estate planning? Well, estate planning is meant to do several things. The first and foremost thing that people think of when they think about doing a trust is minimizing tax liabilities or taxes at death. But it's also a vehicle for health and financial decisions when you're still living. It's actually an important document, along with some others, to help you during the time when you're incapacitated mentally, and who's going to pay your bills and such. And the last is really to provide for where your assets will go when you pass away. And this is the opportunity where you can pass them to loved ones. You can include your charities. And that's one place to make these bequests that Chanel was talking about. So why do people put it off? Well, people put off doing estate planning for many reasons. And if you don't have a estate plan, you may pick one of these as your reason. If you don't know where to start, it's very overwhelming information. There's a lot of resources on the internet, but those don't exactly tell you what's going to happen necessarily in your place of residence, or really give you necessarily the good information on how to make a sound plan. You may think you're not rich enough, you're not going to have taxes with the exemption at the level that it's at. And California not having a death tax, you may think it's not for me. That's not true. And we'll talk about that later. You may think you're not old enough. there are many administrations and probates that I handle for clients who are way too young to have passed away and unfortunately do because of accidents or health conditions. People don't want to talk about death. It is the hardest conversation that you will have because you're planning for a time when you're no longer here. If you're single or you have no children and so you feel like, somebody will just deal with it when I pass away, that is true. But if that's the case, there's a lot of good that you can do if you actually do a plan. It's too complicated. It can be complicated, but it can also be very simple depending on your situation. It's too expensive. Costs to create estate plans vary among attorneys. And it's very important that you talk to more than one to get a feel for how you feel about that attorney and that relationship that you'll establish, as well as whether or not they fit into your budget. And takes too much time. Depending on the type of plan, if it's a very simple plan, then, for me, as long as the client's calendars are open, we can get an estate plan done within 30 days. Those are basic estate plans. Some can take longer than that, but for the most part, it does not take too much time to create. What kind of plans are out there? Well, if you don't have any kind of will or trust, then you have a California plan. We'll talk about that in a moment. You can also just do a will plan. A lot of you probably have beneficiary designations for retirement accounts, perhaps even bank accounts. Some of you will know and recognize joint tenancy, which is what many bank accounts of married couples are, as well as on your deeds to your homes and other properties. And the other is the living trust and the documents that accompany that living trust. That is also a different type of estate plan. So what is California's plan? Well, California's plan for you is what they call intestate succession. California has created a chart that determines who gets your things when you pass away. If you're a married couple with children, those things will typically pass to your surviving spouse, so long as it is all community property. If there's some property that you've received by inheritance or gift, that's considered separate property. And there's a lot of rules about commingling those assets. But if you have separate property, your spouse and children split those in certain percentages. Again, it depends on how many kids you have. And so I won't belabor you with the details on that, but that's how it goes in the first instance. If you don't have any descendants, meaning children or grandchildren, then intestate succession will go back up through your parents to find your nearest living relatives. So the plan is set up to pass it to the family. It is not a situation where it goes to the government, like many people think. That is a myth. Although at some point it can end up there if we cannot find any heirs. If you have California's plan, you will certainly, most certainly end up with a probate proceeding. And that takes years potentially and costs a lot of money. And if you don't have an estate plan, you are also most likely need a conservatorship at some point in your life. Conservatorships are court proceedings that establish who will be your caretaker for finances and for your medical decisions if you cannot make them yourself. So rather than you choosing those people in an estate plan, it's a free-for-all for who decides they want to step on board and do that for you. And what is a will-based plan? Well, as many of you may know or have, a will simply says, I would like certain people to be my agents to administer this estate. And I want my things to go to A, B, and C. Maybe it's the spouse, maybe it's the kids, different percentages, different ages, different times. It also allows you to choose guardians for your children if you have minors. and allows you to select a conservator so that you can already have a name in place. In some of these wills, you can choose if you want to be buried or cremated, if that's really important to you, but not all wills have that information. If you do have a will-based plan and you didn't create it yourself and you did it through an attorney, you probably also have an advanced healthcare directive, so a power of attorney for health, as it could be called, and also a power of attorney for finance. Those two documents will avoid the need for conservatorships. And so those are two important documents. I call them companion documents because they accompany these types of plans. In that way, you can avoid conservatorship, but you cannot avoid a probate. So at this stage in how the world is working and how we do estate planning typically, and most attorneys do it this way, a will-based plan is a bit antiquated anymore. Most people want to avoid probate. A probate is a public proceeding. You go to court, there's a bunch of people in there that hear your story. They know your assets, how much money you're passing, and who you're passing it to. Are you disinheriting somebody? They will know. And it's not just the judge and the attorneys, it is also all the people in the courtroom. Probates are also quite expensive, and we'll have a slide on that in a moment. They take more time. And because the courts are busy, they actually take longer now than even what we would normally see. There's also lack of control. It only works at death, and it only deals with assets in your name. So during your time of disability, you hopefully have a durable power of attorney for finance and one for healthcare, because your will doesn't help with that during that time. It only comes to existence at your death. It only deals with assets in your name. So if you have joint tenancy assets where your property passes to another person as a joint tenant, or your bank accounts are in name with joint tenancy of somebody else, those don't pass through the will. So if you wanted the house to go to someone else, it won't happen that way. That's the same with retirement accounts where you have beneficiaries designated on them, and so on and so forth. It only deals with assets in your individual name. So once again, it's a court supervised and public proceeding. And that's just to make sure the beneficiaries have all of the protections of the court against those people who are managing this probate on your behalf. You have a probate whether there's a will or not. We talked about that a moment ago. You'll see the time is about 9 months to 2 years. And the cost can be about 6 to 8% of your gross estate. So for example, if you had $1 million, and most people with a home and some bank accounts come close to that, you would have $46,000 in fees that go to the attorney and the executor, and that's the person who's managing that probate. Plus you have something in the area of $30,000 plus in fees to the court, appraiser, and publication. Now with these fees, there could be more or less depending on the type of assets or issues that you have in the administration of the probate. But you can see what a large chunk of money gets taken out of your estate and passed on to others that are not your beneficiaries. Minors and incapacity. So as I mentioned before, if you become mentally incapacitated, dementia, Alzheimer's, traumatic brain injury, and things of that nature, you would need to have a conservatorship if you don't have an estate plan or a durable power of attorney for finance and for healthcare. This can be a very expensive proceeding. Typically, conservatorships of the person and estate, that's what the person in finance deals with, can run in about $3,000 to establish, and every 2 years they can run between $3,000 and $5,000 for a simple person's conservatorship, because every 2 years you must report to the court. It is a public proceeding, the conservatorship is, and people know and have access to all the information about your finances and what is being spent on your behalf. So it's not a good thing. The other thing is that if you don't have a plan and you're just going through probate, you have the issue of guardianship of minors. You can choose who your guardians will be in a will, so that's good. But you can't do it during incapacity. So if you become incapacitated and you can't take care of yourself or your children, and you don't have a durable power of attorney or advanced healthcare directive, you haven't selected guardians. So you may have grandparents fighting over these children who the last thing they need is that kind of a proceeding and spectacle. Guardianships are always something that needs to be established in court. So even if you've selected them, there is no alternative to a court-appointed guardian. But if you have something like a trust, you can avoid a guardianship of the estate. And that is a guardianship to manage money on behalf of the minor. Again, these are time consuming and costly. So if the kids need something now, it's going to take some time to get the ability to do so, to get the authority to do so. The other thing that is something that affects whatever type of estate plan that you have, including a trust, is how your assets are titled. So we've already learned that if they are in your individual name, then they will likely be probated, and that's how they get transferred to the next person. You can also have beneficiary designations, and you can have this for bank accounts or retirement accounts, and they will just identify who your beneficiaries are. Most of you most commonly will see this when you're picking out your 401k beneficiaries, let's say. Some of you may have them on your bank accounts. You can also have joint tenancy on your deeds. This isn't the best planning technique, and I will share with you why. If you, let's say, are a married couple, husband and wife, and you have your home in joint tenancy, you have your bank accounts in joint tenancy, you are beneficiaries of each other's retirement accounts, and let's just keep children out of it at this point, and one of you passes away. There's not much issue in how this will pass, and you could probably avoid probate if you've been diligent enough to make sure you've designated beneficiaries or have a joint tenant. The problem comes in at the second death. At the second death, everything is in one person's name, and you will have a probate. The other issue is if you don't take advantage of estate planning techniques, and you are you may have a estate tax issue. There's some discussion about lowering the exemption. And if you have a few properties and a good money manager, perhaps, or you're a really great investor, you may end up over the exemption on your own, and you won't be able to take advantage of your deceased spouse's exemption, which we could do if we did some estate planning. So it's not the best planning technique, because eventually it will catch up with the remaining one to die. Okay. So let's talk a little bit about revocable living trusts and why those are a good idea to have. And on the next slide, we'll see you've got estate management. So there's instructions in a trust for all phases of your life. That includes if you're incapacitated, and that's just mentally, not physically. So again, dementia or other health ailment, illness, end of life perhaps, and traumatic brain injuries or whatnot. There's instructions in the trust to say how this money should be spent for your well-being during your lifetime. Perhaps it's your spouse managing it at that time for your benefit, but the instructions really are for those who follow the two of you. It also allows for a smoother, less complicated transition from phase to phase. So when you do become incapacitated, and we live so long now, there's a big likelihood that we all will at some point, then there is instructions for the transfer of power to either your spouse or the next people that you've chosen. And it's very simple administrative work that an attorney can do quickly. And then there's the second transition, which is when one dies and then when the other spouse dies, if it's a joint trust or just after the death of the remaining person. And again, that's an administrative task that you'll want an attorney to help you with. It is about 1/3 of the cost of a probate, depending on how complicated or simple your estate plan is and how complicated or simple your assets are. So it can be significantly reduce the cost. A little bit more expensive on the front end, typically, less expensive on the back end, but also a lot more smooth, less public. It's meant to be a private proceeding, and hopefully an easier transfer of assets. It does avoid probate. The caveat is that you have to make sure you've transferred the assets in the correct manner and way so that your trust is what we call fully funded. And that means that it owns and or is a beneficiary of the assets that belong there. It also allows you to set out guidelines for your dependents and pets. So if you're incapacitated and you have minor children, it talks about what you expect money to be spent on for their care. It's also a good tax planning tool. The other thing is when you pass away, it provides for the instructions on where your money should go, how, and at what times. Maybe your kids are not old enough at 21 to receive $1 million. Maybe they are. Maybe you would like trusts for them that you can protect and shelter in certain instances like creditors and divorce. The other ability that you can do for your living trust that I talk to my clients about is you have the opportunity to do gifting during your life and at death here. And one of the things I always ask is if my clients have any tithing that they do for a church or any other kinds of gifting that they do, whether that be to grandkids or to a charity or to their church, something that they would like to continue while they are incapacitated, so long as their financial circumstances permit that. If you don't write that in the document, the law does not permit any money to be spent on others. That's not for the benefit of the incapacitated person. So those instructions have to be in there. Perhaps you live in a different state and you want your children to be able to fly out, but they can't afford it, and you want the trust to pay for that. So that's something to consider. And of course, at death, we'll talk a little bit more about where you want your money to go, children, and so on and so forth, and how that works. Before I go on to durable powers of attorney, just real quick about the tax planning. There is a component of tax planning in creating trusts, and there's income tax planning, as well as estate tax planning. Each of those could be a very long discussion, and so I won't go into detail in that. But there's always a component, whether or not you are very wealthy, to consider some of the income tax planning benefits that you can have when you create trusts as well. And we already talked a little bit about durable powers of attorney. They are very important to the plan that you create. Again, they will avoid conservatorships of the person in a state. They will give your agent the ability to fully take care of you. They will, during life, give access to the agent to deal with Social Security and medical companies and things of that sort. And the medical power of attorney gives your agent the ability to make medical decisions when you cannot. So these documents are only during the time where you are living and unable to make your own decisions. The durable power of attorney can be effective immediately, and some people have that, but they don't need to be. They can be effective only when you become unable to make your own decisions. And so these are very important companion documents to any estate plan, because the goal is not just about where your money goes when you die, but how you're taken care of while you are alive. And now we're going to talk a little bit about charitable giving, because after all, we are here all with the 10 Talents Foundation. And so this is a really good time to give you guys some idea of where these charitable components come in. You are all here. I'm thinking because you are gifted minding, and you're looking to 10 Talents to help you do some of that. So you can do a lot of charitable giving through your estate plan. And if we can go to the next slide, I'll show you guys a planning pyramid. So this is typically how planning comes into play for most people. The first and foremost thought in estate planning is to provide for your personal protection. So privacy of the administration of an estate. So probate avoidance is another term we can use. Dealing with times of disability. So if you're unable to make your decisions, who's going to make them and how will they make them? And also protecting you during retirement. So how are you going to plan for retirement? Where's the money going to come from? Where is it going to be? Then you think about family planning. Where is this money going to go after you pass away? Do you want it to be specifically distributed to your kids or family members? Do you want it to stay in your bloodline or include your kids' spouses? Do you want it to pass down to the grandkids? Do you have issues with your children? Are they spendthrifts? Do they simply spend money, get in trouble? Do you have any addiction issues with your kids? Do they have jobs that are highly risky, very entrepreneurial perhaps? Even doctors that are potentially liable for malpractice and liable for suits just really for many reasons. Do you need to protect that? And this is an area where charitable gifting can come in. So for instance, you can either say, I want 1% to a charity or a foundation or something like that to go immediately with the amount going to my children. Perhaps it's a tax planning question where some money needs to go to charity to drop you down so you don't have an estate tax. And perhaps you're just simply looking at the fact that maybe you have children and grandchildren, but what if your bloodline all passes away and you're left with money to go to whom? Do you want it to go by intestate succession, which is the default if you haven't specified somebody? Or is there a favorite uncle, aunt, friend, or charity that you would like to donate to? And that's one place where you can put in charitable giving as well, including during your lifetime. Like I was saying, if you are giving now and you would like to continue to give during disability, then you can write that into your plan as well. I already talked a little bit about the legacy planning. That is when you are planning because you have so much wealth to give that it also, allows you to provide for your family as well as give to those charities that you enjoy. And we move up to the pyramid where there is a point in time where charitable giving can become part of your tax planning strategy to minimize the amount of taxes you would ultimately pay. And those are very complicated plans. And those are, it's sort of like a building block. You build a pyramid, you create your base plan, and then you build up from there. What donors are really planning for? So like we talked, really what you're planning for is making sure your spouse is taken care of when you pass away, making sure you are taken care of if you are disabled, that means unable to make financial decisions, that you are planning for your minor children, and also even your older children to make sure that you're protecting from any bad decisions. Not all our children are this way. There's many times where we just write checks to them. but you may want to explore that protection for them. And keeping money in your family in the way you wish to do that. That could even include kids that are, in essence, adopted children, but they're not legally yours for purposes of being in your bloodline. And like we talked, donors give for various reasons. They are charitably minded. Many of you are, because you are here. Probably because of your upbringing and the values that were instilled in you, or the charity of others that you received, but also for tax planning, so that you can kind of kill two birds with one stone. Rather than provide tax money to the government that you don't know where it's going to go, maybe you'd like to direct that amount to a charity of your choosing instead, that you know is going to fulfill those things that you hold near and dear. And just to recap how you can give directly, which is right now, you can write a check, as you all know. If you tithe, perhaps you give it to your church, or you donate to the school fundraisers or other types of giving. Those are direct charitable giving, and that's also immediate. You can also give periodically. Many sites ask you for a yearly donation or a monthly donation. You can also give whenever you feel, whenever the chance comes where you feel like a good donation makes sense. Or for specifically the purposes that I was here to give you guys through your estate plan, your trusts, your wills, and these documents that you can give and pay forward. And again, these are the different ways that you can give. You can do specific distributions in your estate planning documents that say, when I die, I want this amount to go to X, Y, and Z charity or X, Y, and Z person. An ultimate beneficiary. So perhaps you put a beneficiary on yours, kind of double on there. You can put a beneficiary on a retirement account or a savings account or some other asset that you'd like to directly pass. Or you can do something like a tax saving clause. So you can develop these advanced estate plans to do charitable trusts and things of this nature, creating foundations. And those are more complicated. When you're creating trusts, if you're not just giving directly, you can do it through your living trust. We've talked about that. You could do it through life insurance trust. Now, these ones, anything after the revocable living trust, those are generally tax planning trust options, and they are complicated, but they are available to those who it would make sense to create them for. The issue with those is that you need to be aware that you give up some control over your assets when these are created. And so they truly are a case-by-case analysis of your financial standing and your wishes on how to pass your wealth. But the revocable living trust, and that's briefly what we touched on today, would be a good resource for where you can put your charitable gifts. And of course, last but not least, I do have to put a disclaimer on. Of course, this advice is general. It is not meant to be specific to any single person, nor even the answering questions. I must do those broadly, but I'm happy to answer them all. And of course, we have not created an attorney-client relationship. I know that Chanel would be more than happy to get you a list of resources if you do wish to speak to an attorney. I'm sure she has a list of fabulous attorneys that you can speak to about your specific situation.
Thank you so much, Alice, for all of that really good overview information. I feel like, especially as someone in my 20s, it's so valuable for me to have this information at my age and to be able to think about these things. I haven't seen any questions come through in the Q&A box, but we have about 10 minutes for participants if you guys have any questions for Alice. Again, she can't answer depending on the specificity of the question, because she's not your attorney, but anything general about what was in the PowerPoints, you can still put that question into the Q&A box, or at this time we'll also allow you to unmute and you can ask a question out loud as well. So Alice, I'm going to give people a minute to think, and while they're thinking, I have a couple questions that popped into my mind while you were talking. One of them being with the charitable component. Say that somebody who's listening today is learning about bequests for the first time and they're interested in adding a bequest to an existing will or trust that they have. How easy is that process, or what would that look like as next step for them? Is it pretty easy to go to their attorney and say, hey, I would like to put this in?
Yes, it's not a difficult thing to do at all. It's definitely something you would call your attorney and you would let them know you want to make an amendment to your trust and that you'd like to add a charity. What they would do is, depending on how you have it drafted, it would be either changing that disposition section that says, let's say 50-50 to my kids. Perhaps you have a percentage and you want to add the charity in for a percent. Alternatively, you can just add a gift. If you add gifts, what happens is gifts come off the top. So let's assume, for instance, that both husband and wife pass away and we're administering this trust at the second death. First, we're going to look to see if there were any gifts of any specific assets or amounts. Those will be made first. Then the remaining amounts get split in the percentages. So you can say give $10,000 to, a person or a charity. So your estate value will be deducted by 10. Of course, first all the expenses get paid, but then the remainder gets split 50-50. So there's a couple different ways you can do it depending on what works best for your particular situation, but it's a simple process to do. The other thing too is when you make a gift to a charity, many foundations and many charities, many nonprofits, if you make it generally to the nonprofit, they can use it for charitable purposes, but in any way. And there are charities and foundations that have specific purposes that they fulfill, and kind of like separate compartments. So maybe a charity has a scholarship, or maybe they do something else. You could specifically direct it to a particular portion of that charity's portfolio. For instance, if it's a pet organization and part of their organization deals only with labradoodles or something like that, then you can actually direct your gift specifically to a component of that charity if they have them.
That's interesting. I didn't know that. Okay. Any questions from participants?
Thank you all for listening. I just want to say it's a lot of material. Even a quick overview can be confusing sometimes. Happy to help answer any questions. If you guys have any, you want to email them to Chanel. She can forward that to me, and I'm happy to answer them after that. But it is definitely something to follow up on for all of you if you don't have a plan, or go back and talk to your attorneys if I've created questions. I think we have a question here.
Yes, it looks like Paul has a question. So he's asking, what about the family when you give children's money to an organization? And I think, Paul, correct me if I'm wrong, I think where he's coming from with that is if somebody puts a bequest in their will or trust, and then their children find out about it after they've passed, how do you manage that relationally? It could possibly put the charity in a difficult or awkward place.
Well, and so in most cases, if you're charitably minded, your children probably know if you would rather give to a charity because perhaps your children aren't exactly acting in a way that you would have hoped. And so you want to find an alternative for your money. Maybe you want to disinherit your children. That's something that does happen from time to time. Or maybe you don't think they need it all. They will find out about it eventually, because as your blood heirs, they have to receive notice of this administration. And so when I counsel my clients, we talk about these types of things in the family relationships and how do we handle those before you die. It could be something like talking to the children and letting them know, hey, this is really important to me. I want to provide to this charity. So it's not a surprise. If your relationship with your children isn't good and you're not speaking with them, then they shouldn't be surprised to not receive. And a lot of times when I talk to kids, I always say it's better for your family, your parents, to spend the money while they're alive than to have any to pass on, right? The goal is that the gift is that you take care of yourself and your kids don't have to pay for any of your care. That's really the goal. Sometimes the goal is to provide for your children because maybe you don't think that they can provide well enough for themselves. And we always think about leaving a legacy and whether that's money or not. But yes, at some point they will find out. And the charity, if it's in your estate plan and it's being administered, they have the right to that money. They would challenge perhaps the terms of the trust, and there's no contest provisions, which is what many of you have heard about. And so they wouldn't, if they challenge it, either they're successful, which is unlikely if you've gone to an attorney, and they will simply not get anything, even the small amount that you may have provided for them, depending on how you've drafted your trust. So eventually they will find out. And the key is, it's not about just preparing documents for you, as an attorney anyway. For me, it's not about just preparing documents for you. It's talking through these types of situations and managing. You don't want to leave your children in a worse emotional position than before you had drafted documents. And sometimes the kids don't receive an equal amount. When we deal with that, sometimes they get hurt because they're not your primary person on your documents. And so we talk about how to handle those situations so that when you do pass away, you actually leave your family intact rather than split them up because of arguments later on. So that's something I would talk to my clients about. Paul, does that answer your question? Great.
Yeah, he said yes. And I would chime into that also, Paul, and for everyone else listening. I think the principle of talking to your family about the decisions that you've made in your estate plan is really important. And so if as a nonprofit leader, if you have a donor that comes and says that they have included your charity in their estate plan, you would want to counsel them and encourage them. Hey, have you talked to your family about this? Do they know what your plan is? And encourage them to have those conversations before they pass away, because that'll make it a whole lot easier on your nonprofit and to help you avoid, those possibly awkward confrontations that we fear. Okay. And we still have a few more minutes if you guys have any last minute questions that come up, but I also want to close real quickly just with next steps here. I think there might be a couple of different situations of people who are on this call. If you're somebody who doesn't have a will or trust in place at all, and that's a step that you would like to take, but you're not sure where to start or who to start with, you can contact us at 10 Talents Foundation. The phone number and email is on the screen, and we can help put you in touch with an estate planning attorney in the Fresno area who would be a good fit for your needs. And that's something that we will make those referrals free of charge. The estate planning attorneys charge, of course, but that's something, a connection that we can help make for you to find somebody who you can't trust. And then also for those of you who might have a will or trust already in place but are interested in adding a charitable component, if you have additional questions about that, you can contact us at 10 Talents as well. Or if you already have an estate planning attorney, that's something that you can talk to them about more details of what that would look like. So thank you again to Alice for taking your time to be here. Thank you to Cheryl Root and Ashley Goldsmith, who are also in the background on this call, helping us to run everything smoothly. And thank you to everyone who took the time to attend today.
Thank you, everyone.